From Jackie Benestante, maybe Jackie, you can Benestante who's the executive director of the Texas Autism Society. Jackie, thank you so much.
Yeah, thank you. Like everyone here, we are profoundly relieved that the state of Texas has halted the scheduled execution of Robert, an innocent autistic man. Everybody who's been fighting for Robert.
Thank you so much, Jackie. Next, we may be hearing from Kate Judson, who is the executive director of the Center for Integrity and Forensic Science. Kate, did you want to say a few words?
I can. Yeah, I am so grateful that the court has done this, and I really want to acknowledge the tireless work of Robert's legal team, and just couldn't be more grateful to all the supporters and allies. Thanks, you guys.
And if he's not going to say anything, I must refer to beloved Brian Wharton, who maybe the bravest of us all, along with Robert himself. You know, I've never encountered a situation where a detective on the case was willing to reconsider their presumptions, their conclusions, and learn and study and search his soul. And, you know, Brian did all that and more. And I think he too has been saved by this decision today, because I think he and I would have had irrevocably broken hearts. But Brian, you are a brother to me forever, so I'm glad you're on.
Thank you so much, Gretchen. And now, if reporters would like to put their questions either in the chat or raise your hand, you'll be unmuted. Thank you so much. We can't hear you.
Hi, can you hear me?
Yes, who is this, please?
Hi, this is Karen Hua here with CBS News Network. Gretchen, we interviewed you yesterday, spoke on the phone with you this morning. Can you just explain to us what happens going forward now? So the execution has been halted, but what are the next steps for you and your team?
Thank you for that. Yes, I think it's a complicated ruling to understand right off the bat. We all get it that the execution is off. So that's the good thing. But when I said only the battle has been won, it's because Robert has not yet been awarded a new trial. What he's been awarded is the right to go back to the trial court level and try to demonstrate before that court that he too should be granted a new trial under the Ex Parte Roark decision. So this is the Shaken Baby case that the Texas Court of Criminal Appeals issued last October, in which it made many holdings about the fact that Shaken Baby syndrome has not withstood the test of time, that many of its presumptions have been completely dismantled, and that because that case was tried from beginning to end, as Roberts was, as a Shaken Baby case, he was granted a new trial. And then instead of a new trial, he ended up being exonerated because the district attorney in that case recognized there was no basis for pursuing that new trial. So we have to fight this battle essentially again, but in light of that change of law. Because I will point out that the only time we have had a chance to put on witnesses and present some of the new evidence of both change science and actual innocence was several years ago now, before the Roark decision. And so the findings made by the previous trial judge were without that guidance from a higher court. So we will be able to go back to a new judge at the trial level and utilize the Roark case to make the case that it is, whoops, I'm having trouble.
Yeah.
That we can make the case that these cases are materially indistinguishable, and that just as Roark got a new trial, Robert should too. But this is not something that's going to happen tomorrow, but I can tell you I have already sent an email to an attorney in the Attorney General's office asking, are they going to continue representing the state? And let's get a hearing. Let's get back in the courthouse.
Thank you. We have a question in the chat from Michelle Pitcher with the Texas Observer, Gretchen. how did Robert find out about the stay and what was his reaction?
Well, I wish I could tell you. The first thing I did was call the prison, and I thought I was going to be smart and go right to the warden, and they're like, "Well, who are you?" I tried saying I'm a lawyer and my client has just gotten a stay of execution. Well, that wasn't good enough. So they wouldn't let me talk to the warden. I said, "Can I send you the decision so you can tell my client?" And you'll love this. They said, "No, it has to come from the Office of Attorney General." And why that is amusing to me is they are our opposition here. So I hope they will share that decision very quickly. But I imagine Robert probably heard through the death row grapevine, which is quite porous because folks on death row are frequently listening to the news on the radio or receiving messages from supporters where I'm sure they got the word to Robert very quickly. But I don't know. I've communicated with his family, but I haven't been able to talk to Robert. So after this is over, I'm going to quickly schedule a visit to get back there. I was there with him yesterday, and it was a rough day. And I cannot wait to have that next visit with him because I was, quite frankly, terrified that yesterday might have been the last time I ever spent time with him.
Thanks so much. We are not seeing any other questions in the chat or any hands up. Oh, there is one up. Okay. If you could, Amelia, unmute. Is that Dakin?
It is, yes. Hi.
Thank you.
Hi, Gretchen. Thanks
Hi
From
there.
CNN.
I wonder, could you talk about, Gretchen, could you help us understand how the CCA's decisions today on some of Robert's other applications, how's that going to affect the type of evidence, if at all, will it affect the type of evidence that you can bring to the trial court? And will it complicate your effort at all? Can you just talk about that a little bit, please?
Yes. I mean, what you all are probably aware of is that we had multiple things pending in the Court of Criminal Appeals. And both of our applications based on new evidence, both new claims, new actual innocence claims, new junk science claims, and new judicial misconduct claims were all pending. All of that got dismissed. And there wasn't an explanation for why they were dismissed other than a citation to a procedural bar in Texas habeas law. And I'm going to have to sort that out. And there may be, that doesn't mean those issues are dead, but it means this is not what happened today, that we did not get it. We're not getting a chance to develop those new claims. What they did is they looked back at a habeas application we brought last October when the previous execution date was looming right after Ex Parte Roark had been decided. And that the whole point of that application was, look, the law just changed here and these cases are materially indistinguishable. Robert should get the same relief, but that too was procedurally barred without an explanation. So they went back to that decision. And it's called reconsidering on the court's own initiative, which just means we can't ever beg them to reconsider. We can't file a motion specifically asking for that. We can suggest that they reconsider, but it has to be their own internal decision that something maybe wasn't correctly resolved. So that's the insight we have today, is that there were enough members of the court who are troubled by the inconsistency between granting relief under Article 11073 to Andrew Roark, but then denying it a week later to Robert Roberson. I will note that last year we had 4 judges dissent when we were denied, suggesting even then there was a sense that there was an inconsistency. So now there is a majority that agreed that this needs to be examined. But they didn't resolve the question of whether or not Roark means relief for Robert. They are sending that question back to the trial court. And it's interesting that there was at least one judge who felt we really should be getting a new trial right now. And I appreciated that presiding Judge Shank took the time to explain why he felt like that should have been the relief. But the way things work with courts, judges can have different opinions, but ultimately the holding is where do they come together as a majority. So the only issue where they came together was on should Robert get relief under Article 11073 because of Ex Parte Roark. And I hope that answered your question. And if not, feel free to ask a follow-up.
And I think now Juan Lozano of Associated Press.
Good afternoon. Thanks for taking my question. This is for Gretchen. Do you think if the Court of Criminal Appeals had not issued its ruling granting relief in the Roark case, would Mr. Roberson have gotten a stay today? Like if that case had not been ruled on, didn't exist, do you think he would have gotten a stay today?
It would be hard to say. I mean, that's like saying, you know, I'm gonna rely on chaos theory. The variables that might have reshifted the universe, I can't attest to. I know that Roark changed the legal landscape in Texas and should mean relief for Robert. And maybe that's, you know, really the most pressing issue before the court is one inconsistency of the jurisprudence. For me, Robert is actually innocent. It's not a probable, a possible, he is actually innocent. And I still hope to be able to prove that, which shouldn't even be our burden. But I would like to prove that and get him home one day.
And just a quick follow-up, do you, I guess, were you surprised that because I know that it's ruling, the court said that on its own initiative, it decided to reopen this habeas application that you had filed last year. I guess, were you surprised that they did that on their own? Because they, in the ruling, they pretty much shut down all the other claims you had made, but they decided to reopen this one. I guess, were you surprised that they did that on their own?
Yeah, I wouldn't say surprised because we had expressly suggested part of when we brought the new habeas claims in February, even in the title of our pleadings, we urged them to consider going back. And part of the argument was you really cannot reconcile what was said in Roark with denying Robert relief. And I think part of this, and Representative Harrison alluded to this a bit, there is plainly some confusion about what went on at that trial in 2003. And, you know, this, I think, is going to be part of the next round of clarification to the new judge, is looking back at that trial. I mean, it started with a shaken baby diagnosis. That was the basis for Robert's arrest. And shaking baby terminology and a shaking baby expert were central to this case, in part because there was virtually no evidence whatsoever that Nikki had any other significant injuries, any external injuries other than a minor bump on the back of her head and some very light bruises. This was not a child who looked like she'd been battered. The basis for assuming a crime was the hypothesis known as shaken baby. So we're going to have that fight. That's going to be core to saying this is what he was tried for. Therefore, Roark should apply equally. The science has changed. We'll need to show that. And we'll need to show that the change in science is material to the conviction, that if a jury today heard the new science, there's a reasonable probability he would not be convicted. It's a much lower bar than proving actual innocence.
Thank you. Robert Arnold from KPRC.
Hi, good afternoon. Thank you for taking my question. I have two questions. One is quick. Is there a time frame or a deadline for having this particular issue resolved in the trial court? And secondly, does the fact that the CCA grant relief based on 11073 give you somewhat of a leg up in your argument against the Attorney General's office, which has tried to say, no, this wasn't shaken baby. He beat her to death, essentially, because the trial court, I mean, the way I read the CCA's ruling, they're acknowledging that this was a flaw in the science at the time of trial when the AG's office has said, no, this really isn't about science. He just beat her to death.
Right. I'm gonna try to take, but those are such, the one's an easy question because I have no answer. There is no timeline. Sometimes the Court of Criminal Appeals will say you need to resolve this within X amount of time. I don't believe that's in this decision. And I will also say those kinds of dictates are more honored in the breach than the observance, because it really depends on what the litigants can get done. But I'm determined to push this as fast as possible. Robert has been waiting for 23 years already. So I am going to be all about speed. But as for your other point, they did not reach the merits of deciding this was a shaken baby case. But you're right that it plainly shows many of the judges feel it is, and that they want the trial court to dig into this, which means looking back at the evidence. What is, and I will say there is absolutely no objective medical evidence to support this notion that Nikki was beaten to death. There are, in fact, grotesque falsehoods that have been circulated that are easily disproven if you look at the CT scans, the medical records, the blood work, etc. So you can say whatever you want. It's like, you can accuse somebody of being, from another planet. Well, can you prove they came from another planet? I don't think the AG can prove what it's been saying out there in pleadings and on social media. But I think that will be where we join issue. They'll have to show that it really wasn't a shaken baby case. And if you look at the trial transcript, you can't really make that argument with a straight face. Plus, even the judge in 2021 found it was a shaken baby case. She just said shaken baby science hadn't changed that much. Well, now we've had the CCA say, oh, indeed it has. And that is the point of Ex Parte Roark.
Thank you. We've heard from a number of reporters, either in the chat or elsewhere, that they cannot raise their hands. So I'm going to, if folks have my email, you can email me your questions, or and I'll read them to Gretchen, or you could say that you want to be unmuted. We have a question from Bethany Erickson of D Magazine. And she's wondering, Gretchen, if you have any thoughts about what was written in the Marshall Project this week about the psychopathy checklist revised or done on Robert.
I will say that's yet another outrageous fact from this trial devoid of any due process. Because that was, it was a death penalty case. There was the state had the burden to try to prove future dangerousness. So they hired a psychologist who went in and did this hair psychopathy checklist, which many have also characterized, by the way, as junk science. But even David Hare apparently was asked to take a look at how it was done in Robert's case. I wasn't involved in this. This was a journalist doing this. And David Hare himself said this was improperly administered. It doesn't make any sense. And I will point out, by the way, you take someone with pronounced cognitive impairments and autism, and you don't account for that in doing this checklist, that is beyond junk science. It's very misleading. And so that's unlikely to be an issue in our current proceeding. But it is part of the tragedy of this case that things like that were going on and they weren't really being challenged. And his appointed defense lawyer put on essentially no mitigation case because everybody started with the presumption that he was guilty of shaking his daughter to death. Even the few people the defense put on, they were starting as, Ground zero was he shook his child to death. All right, and then come up with something to justify that. The whole thing was a travesty, but I don't, that's not going to be an issue here, but it does show a real lack of understanding of Robert, his disability, and, you know, psychological science. I see the hand, Dan.
Oh, good. Thank you. Yeah, thank you, Gretchen. We have a couple questions in chat. I don't know if Jamie Landers can be from Dallas Morning News unmuted. Amelia, if you can try that, and Jamie, if you can let us know. But
Can you hear me?
Jamie?
Okay, I'm echoing a little bit, but it's working. Thank you. I wanted to ask, in terms of next steps, if you could elaborate on, whether or not the state can appeal this decision before the execution next week, or is there some sort of timeline that starts all over right now just based off of this decision alone? Could you just clarify that?
Certainly, yes, there is no court to which the state could appeal this. So it means the execution is off. I am sure by now that the folks at the prison have already taken Robert off death watch and back to his cell. He is part of a tiny group on death row that has special privileges. He's part of this group recreation program, and I believe that they were keeping his cell for him to come back to. So I hope that's already happened. Once an execution date is off, the warrant is nullified, you can't, and then now you have an order of the court saying these things have to happen. No one can rush to get an execution date set again. It's going to take going to the trial court, having that whole process. Then it goes back to the CCA, because under Texas law, no trial court can say, we think he needs a new trial. Go for it. They can only recommend. So, and they can recommend for or against, and the CCA has the power to go either way. They can accept the trial court's recommendation or they can reject it. But ultimately, under current Texas law, no one other than the CCA has power to grant the new trial. So it's going to take at least 2 rounds. And only after we get another decision from the CCA will we know, does he get a new trial?
Thank you. Amelia, thank you for unmuting Tony Quesada, who is from the San Antonio Express News editorial.
Yes, can you hear me now?
Yeah.
Okay, thank you. Well, your last answer may have answered mine, because I wanted to know, at this point, would the trial court have the authority to declare Robert innocent, or not guilty, I should say, and free him on its own accord? And if they can't grant a new trial, I would guess they couldn't go that step either.
No, and unfortunately, I mean, a couple of legislative sessions ago, there was some hard work done by lawmakers to try to get what's called, they were calling it an out-of-time motion for new trial, which would allow parties to agree there should be a new trial, and to basically say, if the parties agree and the trial courts agree, you should be able to cut through this time-consuming process of going back to the CCA. But that did not become the law in Texas. So as of now, the only way to get a new trial is for there to be a majority of the judges on the CCA who say yes. I mean, there are other options through federal court, but those are even rarer. So we will just be, I don't predict that the state is going to concede. I think there's going to be a fight, and I hope an opportunity to put on all the evidence we need to show why a new trial is necessary. So it's different from the trial itself, but you want to amass this record and then convince the trial judge to make that positive recommendation, but then you're still all beholden to the CCA to make the final determination.
And I guess one other thing, at least one, maybe a couple of the dissenting opinions expressed the opinion that that shaken baby science is not discredited and that it's not uh, settled science. What do you make of that?
Well, I will say that in Ex Parte Roark, there were members of the CCA that dissented and took that position. And one of the difficulties here is that in January there was a turnover at the CCA where and one of the judges who is no longer on the bench is the one who wrote Ex Parte Roark. So you have 3 new judges who didn't go through that whole process. And I know that I have certainly experienced in this fight a lot of people just struggle to understand because you've heard the term shaken baby and pediatricians still defend it. There are many who haven't kept up with the science and don't even understand that there's been scientific study invalidating it. So it's understandable that judges would not completely be on board, except that in our legal system, courts are supposed to honor what's called stare decisis, which means once something's been decided, you're supposed to be very cautious about dismantling that. So even if you didn't agree the first time, once that's the law of, here in the state of Texas, it really should be that everybody gets on board. But that plainly didn't happen yet. And so I think that's also going to be part of the challenge to really educate what were the beliefs about shaken baby in 2002 and 2003 when Robert was accused and tried, and where are we now? And for people to understand that the big issue here is, can you diagnose abuse by simply looking at a collection of intracranial conditions and not look at anything else? And that has been totally debunked. And that's why all our other evidence is still very critical to this question about whether shaken baby has changed significantly. So, because many other things, such as infections like pneumonia, like genetic disorders, et cetera, all can cause these same symptoms. That was not known in 2003.
Yeah, but if the court can't set him free, what is the prosecution's prerogative? Is there any chance you could see the prosecuting say, at this point we see the writing on the wall and we're done?
I sure wish, but that's part of the problem is that I've had this come up in other cases where, let's say there's a new district attorney and they look back at a case and think, I would never, for instance, have sought the death penalty in that case, but they can't just negotiate a new sentence. Once there's a conviction under our current law, the only entity that can undo that is the CCA.
Okay. Well, thank
Does
you.
that make sense?
And thank you. And if there's follow-up questions for Gretchen later today, we can address those. Dan Slepian of NBC Dateline and the podcast, The Last Appeal. Thank you.
Hey, thanks, Laura. Hi, Gretchen. Just curious, based on your judicial misconduct claim the other day, do you think it's an inherent conflict to send it back to the Palestinian judiciary?
Well, first I will say 2 things. That was a claim based on newly discovered evidence that I firmly believe could not have been discovered till somebody else unearthed it, because the whole point was it was suppressed. This was not something ever shared with Robert or that he could have unearthed by himself. So whether I really disagree with the dismissal of those claims, but what to do about it is another question. But already, the judge who presides in the court where this proceeding is filed was one of the trial prosecutors. So he has been recused for years. The judge that took over has since recused herself in the wake of the last day of execution. So we had a new judge appointed who is the one who held a hearing and set the execution date in July. And I presume he'll stay on the case, and he does not preside in Palestine. He's in Tyler. And certainly the kind of concerns one might have about a biased community, et cetera, if we're talking about a jury trial, we're not there yet. And so it's really going to be, is this judge going to be a neutral arbiter? And he certainly seems free from, he's not of Anderson County. So I hope that answered that question.
Thank you. We see Representative Jeff Leach is on here. I don't know if he would like to say a few words, but Amelia, you can unmute Representative Leach if he does want to weigh in.
Come on in, Jeff.
Hey, Gretchen, can you hear me?
I can.
Well, I'm glad to be a part of this call today, and I'm just enjoying listening to you, and so appreciative of your work on Robert's behalf. Robert has no fiercer advocate than Gretchen, and so I'm just very grateful for you, and I'm happy to take part in this call today. I don't need to speak at all or answer questions. I'm just here to listen to you, the expert.
Well, we are so grateful you're on, and even more, I'm grateful that you took the time to go visit Robert yesterday. I know that was just profoundly meaningful to him.
Yeah, it was, and he's a remarkable guy, and I came away being more blessed by our time together than I'm sure he was. I will confirm with one thing you just mentioned a few minutes ago, that I did talk with the warden this morning, and Robert has been moved back to his normal
Yes.
cell, and so I wish I was there today to hug him on the other side of this news, but I'm sure that he's having a better day today.
Yes, and I will tell you, folks, why this is so important. When you get an execution date in Texas, you get moved to a different part of the prison that is called Death Watch. And there are a lot more restrictions. You're under 24-hour surveillance. You're fairly isolated. You tend to be only with other people that have execution dates. And Robert had come from a pod where he was with other inmates who had no disciplinary records and thus had special privileges, such as being able to be outside of their cell and congregate together and hug each other. And if you knew how profound that is for guys who spend years without anybody touching them other than officers putting on shackles. So I actually, when I was at the prison yesterday, I briefly saw one of my previous clients who was also in that group. And his message to Robert was, we're all waiting to give him a hug. We want him back. So I'm delighted to hear that may have happened. Thank you, Jeff.
Thank you. Thank you, Representative Leach. We have a question from Kyoto Tanaka from the Asahi Shimbun, the Japanese newspaper. Congratulations to the team. Could you share your thoughts on the reason why Texas had moved to set the execution date in the first place 2 years in a row, especially considering Mr. Roberson's case has been so controversial for so long?
Good question. I mean, the setting of a date last year and this year were circumstantially different. So I'm going to focus on this year. What we saw this year is that the district attorney in Anderson County, who had been representing the state in this matter since the first time an execution date was set, which was, I think, in 2016, and the first day, and then the whole litigation that I've been involved with started. So you have to have somebody who's been handling a case hand off responsibility to the Office of Attorney General was very odd. And it may seem surprising to people, but the Office of Attorney General mostly handles civil matters. They do have a criminal division, and they tend to do two things. They tend to be invited in to try cases where there's a lack of resources or expertise, maybe in a smaller county, or they handle, for instance, sophisticated death penalty habeas work in the federal system. So for someone in the Attorney General's office to step in state court after years of the case being fought was unprecedented. And then to seek an execution date within a week of taking over the case is even more bizarre. And that it was granted, this request, when an appeal was pending, because we had filed in February. So all of those things were quite unconventional. But to be able to answer the question about why, I can't answer that. I can say that we fought tooth and nail to try to prevent that execution date from being set. Or I should say, we fought. We had a hearing. We got heard on the issue, which was not the case last year. And that is a difference. Last year, we objected to the setting of an execution date, and it was set even without letting us come into the courthouse. So we got into the courthouse, but we lost that fight. But that is what created this ticking time bomb while all these appeals are pending that was extraordinarily stressful, I think, for all concerned. It is not normal.
Thank you, Gretchen. Representative Joe Moody just joined the call. In case, Amelia, you can unmute Representative Moody.
Hey there.
Hi, Joe.
Hey, Gretchen.
Glad you
So
can join us. So
yeah, I apologize. I'm actually on the road, but it's hard to be driving a car with like so much excitement about what happened this morning. But it's just it's a testament to the work that you've done, and I mean, you grind it out for Robert and for justice, and I'm just so incredibly like in awe of the work you do. I told you this morning, I was listening to Lester Holt's podcast.
well, unfortunately, I don't get to hear that compliment because Joe broke up. But I will say that it's ridiculous to suggest that I did this monumental thing alone. I mean, the army of people who saw the injustice here and valued Robert's life and the causes that this case represents, it is truly inspiring and energizing. And I hope that will continue because, as I said at the outset, we haven't won anything on the merits. We've won the important next step, which requires keeping Robert alive. But we're still, the fundamental mission here of getting him a new trial hasn't been achieved.
Thank you, Representative Moody. We also have Representative John Boosie has just joined. If we can unmute the Representative Boosie.
I just joined with my colleagues. We were so relieved and excited this morning for the news. I think, Gretchen, your work to bring this to light and to have other people take a deep look has been such an X factor. We know that people that have taken the time to look at this, no matter their partisan divide, but have taken the time to look at this case and see the facts, know that there are way too many questions here. And so I just am relieved. I was asked yesterday, what is it like to walk into the maximum security prison and see Robert, or see a prisoner like that? And I had to go back to my first visit a year ago to answer the question the way they wanted to, because when I went back yesterday for the second time and saw Robert coming down the hall to greet us, it just felt like seeing a friend. I've gotten to know Robert so well, and he's a gentle giant who has never lost hope, never lost faith, and has believed throughout this whole process that justice for him, justice for Nikki, and honestly, bigger than them, justice for all Texans will be served here. And so just so relieved and excited for the news this morning, and excited for the work that everybody's doing. And I know that we're not done yet, and so we got to keep working. But thank you all for everything you've done.
Thank you. And I will just note that October is the month of Nikki's birthday. She was born October 20th, 1999. And just yesterday, Robert was sharing me some details about, how he met her mother, and that kind of, almost comical relationship. The relationship was forged by the fact they were both from Palestine, Texas. So, but it was short-lived, but he, based on this very short relationship, felt, when he heard she was pregnant, felt, I might be the father. And he always saw that as a sign that his life was going to change for the better. And, it used to give me such pain when he would say things like that, because I would think of all that followed, all the misery. But I think that's still very true for Robert, that Nikki is this angel, and he thinks about her all the time. And he's still convinced that, his faith will bear out, that she helped guide him through all this. So that's not a very lawyerly thing to say, but it was really moving to me yesterday. And it was so wonderful to see powerful elected officials drive out to the, Podunk, East Texas, and be there for Robert in this very scary time. And he was so elated by that.
Well, that's just a wonderful note, maybe to wrap on, thinking about Nikki and Robert. Gretchen, I don't think we see any more hands up, but if anyone has questions, please feel free to send them my way. I can get them to Gretchen. You can email me, you can text me.
I have one more
and Gretchen
thing,
has
Laura.
a few more things to say, and then we'll wrap. Thank you.
Yeah,
Emma.
I always have a few more things to say, Laura, that. But some of the folks that need to be thanked here are the folks that have been shining a light on this case, namely many of you. I do feel like that was the essential turning point last year and again this year, that people getting engaged, learning the truth about this case, writing nuanced, well-sourced stories. And, it just has been exploding. And, I've seen people from all over the world responding to this. This is what great journalists do. And I will also say a special shout out to Laura, who many of you have gotten to know, but there is just no greater master at enabling transparency and communication and making sure that the public, through journalists, know what's going on in these most serious of cases. And, stay with us, because obviously the story is still unfolding. But my profound gratitude to you professionals who hustle and work ridiculously long hours and dig up things that I've never found with all the years of knocking on doors, and just keep going. Thank you.
Thank you, Gretchen, and thank you everyone for joining today and for all of your hard work, as Gretchen noted. We'll keep you posted with any developments. That concludes our press conference for today. Thank you.